And what it took away, you heard from her friends and family, and some of the things that you even heard in the trial. You got a little peek, just a little peek, about the personality of Laken Riley. For example, in Lily's 911 call, one of the things she says is, Laken never misses class. Never misses class. That's the kind of person she was. And in our review of all the evidence in this case, some of the things we had to look at were the social media presence of everyone, and there was a lot of digital evidence in this case. And the review of the digital evidence, I want to share with you just some of it, which has been marked State's Exhibit 336, is that Laken was a very joyful and quite silly, playful person. And a lot of that is viewed in her social media. And the Ring doorbell. Running. Same race. And these are just little snippets that we saw in the investigation that we thought would be important to share with the court, that shows not only the type of person that she was, that you just heard from her friends and family, but the true impact that her murder had on her parents. But more than that, one of the things that the court is permitted to consider in victim impact testimony is the impact that her death has on this community. And in that regard, the investigative team has spent a great deal of time out there at the crime scene, Lake Herrick, all of those trails, and looking for things, measuring things, just going about the daily jobs of homicide investigators and homicide prosecutors. And one thing that we noticed that's still there is State's 335. It's a mural, a memorial to Laken Riley that is still up there to this day, that shows the impact of her death on this community. And that is something that Your Honor is permitted to consider in deciding what would be an appropriate sentence in this case. And everyone is correct, and I'm sure we'll hear it. Whatever you do, Judge, you can't bring her back, and it's horrible. But what you can do is give comfort with your sentence. And what you can do and what you are permitted to do, and what I urge this court to do, and what the law permits this court to do, is to exercise your discretion and your judgment in a way that brings comfort to this community, and in a way that a sentence which appropriately reflects the harm that was done in this case. And a sentence of life without the possibility of parole would bring comfort to this community. And no matter what your sentence is today, and it will be litigated from here to 40 years from now, there is at least one person in this courtroom who will inherit it, and that is Lauren Phillips. That is Laken's younger sister. And she should never, first of all, she's growing up without her sister. She's going to have to deal with elderly parents alone. Her children won't have an aunt. She is an only child. And she should not have to worry 30 years from now, 40 years from now, if he comes up for parole, should he might get out. She should never have to worry about that. And your sentence can ensure that she will not have to worry about that. And so in looking at the indictment in this case, Count 1, the offense of malice murder, which this defendant has been found guilty of, in this particular case carries a maximum sentence of life imprisonment without the possibility of parole. It carries a minimum sentence of life imprisonment with the possibility of parole. The state is requesting that you sentence this defendant to life imprisonment without the possibility of parole, not only due to the victim impact testimony, but also because if you read the indictment, which you have obviously, and you're familiar with the facts of the case because you've heard the case, there are several statutory aggravators in this case that separates this case from a regular murder case. And yes, there is malice murder, and all malice murder is bad. I'm not saying there's a malice murder that isn't bad. But there are some malice murders which are more aggravated than others, and this is one of them. Kidnapping with bodily injury, which is the felony murder in count 2, which by the way would be vacated as a matter of law, but not the kidnapping itself, which is count 5. But kidnapping with bodily injury is an aggravating statutory factor under our sentencing scheme in the state of Georgia. It makes malice murder worse than regular murder. And for that reason alone, you should sentence this defendant to life without the possibility of parole. Aggravated battery, which is also in this indictment and which is also the facts and it's also something he's been convicted of, is also a statutory aggravator under our statutory scheme, which makes this murder different and worse than a regular malice murder. So there are aggravating circumstances, which you have already heard, which I will not repeat to you, but that are not only recognized by the facts, but are recognized by our statutory sentencing scheme. So going down the rest of the indictment, felony murder count 2 is vacated as a matter of law. Felony murder count 3 would be vacated as a matter of law. Felony murder count 4 would be vacated as a matter of law. On count 5, kidnapping with bodily injury, the state is asking you to sentence this defendant to a sentence of life imprisonment with the possibility of parole, which is the maximum for that count. And we are going to ask that you run that consecutive to count 1, a sentence of life imprisonment without the possibility of parole for the malice murder. Count 6 is aggravated assault with intent to rape. It does not merge. In fact, it is a separate crime under these circumstances. The penalty for that is 1 to 20 years in prison. The state would be asking you to sentence this defendant to 20 years to serve in prison. Count 7 of the indictment, the aggravated battery, would merge as a matter of law into count 1, so we would not request a sentence on that count. Count 8, obstruction or hindering a person making an emergency telephone call, is a misdemeanor. The maximum penalty for that is 12 months to serve in a county jail. We ask that you sentence him to that and run it consecutive to any other sentence that you impose in this case. Count 9, tampering with evidence, the way that it is actually alleged in the indictment and factually it is a misdemeanor. So the maximum for that is 12 months to serve in a county jail. We ask that you sentence him to that and run it consecutive to any other sentence that you impose in this case. And finally, count 10 of the indictment, peeping Tom, is a felony which carries a penalty between 1 to 5 years in prison. We ask that you sentence him to 5 years to serve in prison to run consecutive to count 1. So to sum it up, on count, the sentence would be on count 1, life imprisonment without the possibility of parole. Count 5, life imprisonment with the possibility of parole to run consecutive to count 1. Count 6, 20 years to serve to run consecutive. Count 7 will merge. Count 8, 12 months to serve to run consecutive. Count 9, 12 months to serve to run consecutive. And count 10, 5 years to serve to run consecutive. And that is the sentence that the state is requesting.